Thank you. I now call on Shirley and Somerville, after which we will come to closing speeches.
Thank you, Presiding Officer. I welcome the opportunity today to debate the civil court system in Scotland. Some of the most important work of the Scottish Parliament is done without fury or fanfare or indeed a packed press gallery, but we do see today politicians working together to improve Scotland. And this is one of the occasions that I would like to congratulate Cathy Jimison and the former Scottish Executive for instigating the review of the civil courts which we are discussing. Lord Gill's root and branch review may not have grabbed that many headlines, but its recommendations have implications for many aspects of our everyday lives. It seeks to improve accessibility to justice, to ensure individuals, families, communities and businesses who face disputes are better served by a modern, fairer civil justice system. Now, the remit was broad, as many members have already mentioned, at 700 pages, so I have chosen to focus on one aspect of the review, multi-party actions. I am delighted that Lord Gill's review recommends the introduction of a form of multi-party action procedure in Scotland. There is currently no formal mechanism in this country for handling cases where a group of individuals have common issues against the same defender, unlike many other jurisdictions. Now, the class action debate has been around for 30 years and more, and opinion does remain divided. There are those that see them as the champion of the underdog against big businesses, others that see it as the friend of only the lawyer, and a fear that they will herald the adoption of a US-style litigation culture. Consumer Focus Scotland has long championed the case, arguing that class actions were essential to ensure consumers can enjoy their rights. Under the present system, where there are many small claims, individuals may not find it worthwhile or even possible to pursue the loss on their own. In bigger cases, such as product liability, specialised expert evidence may be required, which is simply beyond the means of a single party. Class actions could help in these circumstances and could act as a deterrent to illegal action from traders by better holding them to account for their actions. A system which allows people to band together not only improves access to justice, but may also be better for the courts and for the defender by promoting consistency in rulings and avoiding costly duplication. Lord Gill's report suggests a formal class action procedure may have been useful in recent mass litigation in the Scottish courts, such as the dispute over the lawfulness of bank charges. This resulted in 400 actions being litigated in sheriff courts across Scotland, causing unnecessary expense to both parties. A class action could have allowed this to be transferred to one court and managed as a single group. There have been many other high-profile examples of cases where a class action may have been a useful mechanism, from the infamous 80s case of Hoover not honouring its commitment to free US flights, to the recent failed attempt by Ian Hamilton QC to sue RBS for negligence after selling him shares in 2008, allegedly representing themselves as solvent. Mr Hamilton's attempt to trailblaze for a small-scale investor came to an abrupt halt when the case was moved from the Small Claims Court. Potential expenses forced Mr Hamilton to abandon his case, declaring that Scots law favours the rich against the poor. In cases such as this, the introduction of class actions could have been an important means to levelling the playing field and providing a more equitable access to justice. It's not just consumer champions who have made this strong argument, however. The Scottish Law Commission supported their introduction in 1996, although the Court of Session Rules Council decided not to take their recommendations forward. I am pleased that Lord Gill's considered review has now broadly agreed with the findings of the SLC. The case for class actions has recently been brought before the Scottish Parliament's Public Petitions Committee by the Leith Links Residents Association. Residents of Leith Links were moved to approach the Parliament after 40 years of suffering what is locally known as the Seafield stench, foul odours from the nearby sewage treatment works. The residents have felt powerless to resolve the issue and sought to take collective action against Scottish Water, but found that no mechanism was available for this in the Scottish courts. I spoke in support of this petition, and I am pleased that the committee agreed to keep it open until after the publication of Lord Gill's review, and I now look forward to the Scottish Government's response to this petition in due course. There are concerns about the potential for class actions to bring in the type of litigation culture seen in the United States, but Lord Gill has suggested a model which would provide many safeguards against such abuse. Different forms of class action are already available in many European countries without the excesses of the American model being evident. England and Wales adopted a group litigation orders in the year 2000, but there was no deluge of cases, with only 62 GLOs made in the first 8 years. In Portugal, a case only proceeds after a preliminary hearing which considers whether the case is manifestly ill-founded or not. And Lord Gill's review recommends a similar preliminary merits test is adopted here. Cases would also be needed to be certified by courts with one of the recommended criteria that a group action is preferable to any other available procedure. In summary, I believe that a formal class action procedure should be available in the Scottish courts to ensure our system of civil justice is fundamentally fair and the rights of the individual are protected. This would be one of the many tools available in the modern, efficient, forward-looking system of civil justice in Scotland, and I congratulate Lord Gill for his very thorough review, and I look forward to the Scottish Government, the Parliament and the courts progressing with his recommendations.